Very good evening to everyone. I welcome all the members of KSCASI for this webinar or panel discussion. Before we start, I request our chairman, Narayan Chandra Hebsur, to welcome the gathering.
Thank you, Chandru. I bring a very warm welcome to all of you. All the stalwarts are there and legends are there. And this is the first time we have started something called KSCASI Legal Cell, which Harsha is the chairman, and Dr. Prabhakar sir, Dr. Pavan, Dr. Shailesh, Amarkhed, and Dr. Kiran Kumar are part of the team. And they are presenting how we should go legally in safe surgical practice. And this is first time, I think, so we are doing such a seminar. And I feel it will be beneficial to everybody. We need to practice safely and legally, and surgical practice should be comfortable for all of us. For that, they're going to guide us how we should go about. And I request Harsha to please take it forward and start the moderation.
President, Chairman.
Yes, sir.
Sir.
Madam ne bittidiyalla, Kalaivani madam.
Sorry. Kalaivani madam is always there for everything. That's why I forgot. I'm sorry, madam. You're welcome.
No problem.
Madam is without a lady, how can things function?
Before we start, today we are going to have the panel discussion on wisdom of legally safe surgical practice, facts versus law. So this session is going to be moderated by Dr. Harsha GV. He is a consultant laparoscopic surgeon practicing in Harapanahalli, and he has done his LLB also from Karnataka State Law University, Hubli. Along with laparoscopic practice of surgery, he also does he is a legal advisor to some of the legal firms. So I request Dr. Harsha to start this panel discussion. Harsha, please.
Thank you, sir. Thank you, Chairman, sir, and thank you, Secretary, sir. And before I start, I would like to thank and welcome all the seniors and all the president, ex-presidents, ex-chairmen, and the secretaries, and also teachers, my teachers and my friends. Today, actually, for a long time, we had a discussion with Chairman sir and Secretary sir regarding wisdom of legally safe surgical practice, facts versus law. Today, I'm going to moderate this. As already been said by Hebsur sir, the panelists you all know. So I will, without wasting time, I am going because little bit of time constraints. I'm just going ahead. See what really the legally safe surgical practice. Usually, once we become surgeons, we get our license as per the law, which is actually from the qualification what we got is recognized under law NMC. And NMC in nutshell, actually Prabhakar sir will be explaining. Sir, over to you, sir.
Actually, NMC, it was at first, initially it was a medical council, that is Indian Medical Council. Later, it has become National Medical Commission. In fact, the main objectives is to improve access to quality and affordable medical education all over the country. And also, it will ensure that availability of high quality medical profile profession. And also, it concentrates towards the research, and it usually maintains the medical education by frequently assessing the medical colleges on a transparent manner. And also, it enforces high ethics in standards. And also, it gives, it is one of the grievance redressal cell for the both doctors and also the public. So these are the main objectives of NMC. Of course, it will maintain the registration. That is the major function of even the state medical councils. They will also maintain the registration of any doctor who completes their MBBS. Immediately they have to register. So without registration, they cannot practice. So only the person who has come out of degree, taken degree from the recognized medical college is eligible for the registration. And after this MBBS, even the other broad specialties or subspecialties, if they are finished, so they also that also registered in Karnataka Medical Council, and later it will be transferred to even the National Medical Commission also. So in both the national register and the state register also you have. And the registration maybe sometimes it may be dual, especially in the border states where you can have the dual registration, stating that the first state usually, for example, Karnataka means KAR with the same registration number, and Maharashtra, MAH like that, they will have the registration number.
To add, so one of the points, sir, university is again recognized by NMC Act, and university is a special entity where universities are recognized under National Medical Council. And actually, we have multiple universities, as we seniors know that Mysore University was there, and before that there were other universities, and those universities are also being recognized under 1956. University Act is recognized in 2019 Act. So, what is law and act and judgments? Actually, Prabhakar sir and Shailesh sir, both of them can coordinate this one.
Yeah, actually, law. So, as we all know, that any law, even in a common this thing also, it is usually the people who whoever elects some legislators or the parliamentarians. So they will make the law, and it should be this is only for the interest of the people only. So once it is made, then it is the law of the land. So you have to follow this. So these laws, once they're made, usually the public should follow, whether you know it or not. So you have to follow this. So, but our appellant body like NMC, they will not make the laws. So whatever the laws are there, so usually they will follow, and even the act also. And if anything, any amendments, if you want to do for that, or you want to change certain things, so it has to go to the legislators or the parliamentarians to change or to amend the laws. And also, of course, the constitution is the supreme thing. So we have to follow the constitution, and that's how the law will work.
So this one again, Prabhakar sir is going to elaborate this slide.
This is unsafe surgical practice means usually some people knowingly or unknowingly they will be doing or practicing without the registration in the Karnataka Medical Council or the NMC. So we have seen, of course, MBBS usually after MBBS, so many people they will register, and they will not register in the broad specialties, especially the diplomas or even the master degrees also, or sometimes the specialty subspecialty also. So it is, in fact, it is unsafe. If you are not registered, you are not a qualified doctor in that particular field, even though you have done a degree. But if you are not registered, you are not you are not eligible for that. And as a specialty, you have to practice safely whatever the NMC guidelines are there, or even the KMC will give the guidelines, how to practice and all. So the qualification is very important, because without qualification, you can't do anything. So that the qualification means it may be broad specialty or even the subspecialty. So if you are done some master degree, that is general surgery, then if you are done subspecialty like urology, so just because you have trained already in general surgery, you need not do the same surgeries as a general surgeon. So you have to restrict to your subspecialty, unless if it is, because since you have already qualified in MS, sometimes in an emergency cases or this thing, it is acceptable at that period. And of course, there are certain things which are introduced in our syllabus also. Say, for example, some of the things like in a general surgeon, earlier it was head to toe. Those periods, those time, we can do any surgery, even the ENT surgeries or orthopedic surgeries and all. But as it becomes divided into different subspecialties, now the field is also restricted, and we have to maintain the standards in that. For example, what I have learned during my PG days, today it is we are not practicing because it is also advancing and also it is restricting to one particular this thing. And when it comes,
Sir, if I add
is
a
it?
few points, if a person who has done general surgery and who has again done MCH onco surgery, he can register both, but he can't practice both as per the law also, sir, because law of computation works in this same process because the law of land, where he has to he has to practice onco surgery there. If he doesn't want to register onco surgery, then he can register only general surgery, or otherwise he has to give a declaration, I will be practicing general surgery.
Yeah, that's what I told. But only thing
Yes,
in
sir.
an emergency, in the case suddenly, if there's for example, if he has opened for something and he has done, if he found some inflamed organ, he want to remove, so he can do it because he's experienced in that. That's all. But as a practice, he should not practice because he has registered as an oncosurgeon. He has not registered. Yeah.
Now, one thing is, where is the demarcation about what is oncosurgery? A breast lump, fibroadenoma is removed by many people, including gynecologists also. So if I have to do a fibroadenoma, a patient comes to me, I diagnose, I do corneal biopsy, it comes as fibroadenoma, I do the surgery. Now,
No, fibroadenoma,
people say you
gynecologists
cannot do
cannot.
fibroadenoma surgery.
Gynecologists cannot do. Gynecologists cannot do. That's what.
But they are doing breast lumpectomy for malignancy also. I get the cases.
Sir, demarcation is syllabus, sir. If it is mentioned in the syllabus, they can do it.
Yeah, can I add here, sir? With respect to oncosurgery, general surgery, register 1. See, the process of registration is you register your MBBS, then you do your MS. That degree is registered again. Then subsequently you do oncosurgery, you register that oncosurgery. And then you take an appointment in a medical college in a general surgery department. So now, what will that oncosurgeon do? He will do general surgery work or oncosurgery work. This commonly happens in even.
He has to restrict to any one of them, sir. He has
So
to restrict to one of them, sir.
Where he has to report that I'll restrict to 1. Is there any body where he has to report it, or how is it going to happen?
So once he has registered oncosurgery,
Yeah,
he is not supposed to be considered as a general surgeon.
but he's given appointment by the government hospitals itself as a general surgeon department.
That's what, sir. That is the gray area.
For example, even MBBS people also are given appointment in the surgery department. That doesn't mean that he has to do the surgery. That's.
Sir, authorities like government can do some mistakes, and even the appointing authorities can do some mistakes.
Government, see, law says the law cannot be 2 different laws for 2 different same people in the same country cannot have 2 different laws. Whether it is in perspective with the patient or it is in perspective with the professional. So the concept of having 2 similar specialties and not practicing. See, there is a mention on second subject of syllabus and curriculum. See, given a syllabus
Pavan, sorry to interrupt.
Sir.
Pavan, I think so. Let's take the questions in the later part.
Sure.
Harsha, let's keep the questions in our chat box and take it up later.
This slide is for Pavankumar, sir.
Yeah. Okay.
Yeah. This is with skill competent case. That is Moni versus State of Kerala, wherein the principle of the case says that the test for medical practitioners is the standard of skilled man qualification degree, exercising and professing standard of care to have the special skill. The Supreme Court in this case held that the skill and knowledge of the medicine profession will be different for each doctor, and it is quite possible that there may be differing medical opinions, but as long as the profession carries out their duties in an acceptable manner and the court finds that due care and skill have been exercised then the doctor wouldn't be held liable. So this is what was discussed in the previous slide. Hello. Yeah, can you hear me?
Yeah. We are able to hear you.
Yes, sir. This is what was discussed.
The
See,
Prabhakar sir is
Yeah.
sir will be discussing this slide, sir.
yes. Okay.
Yeah,
Regarding the previous point.
hello.
Hello.
Hop on. Yeah, that's what. Actually, the same here also. It's this slide also tells the same thing.
Yes, sir.
But as a general surgeon, you can do cholecystectomy, either laparoscopy or because it is there in the syllabus. So you can do the cholecystectomy, even laparoscopic also. And urologist doing cholecystectomy, definitely it is not acceptable. And general surgeon doing TRP is also not acceptable. Though there were days the general surgeon was doing everything, but at present TRP is not acceptable. Definitely other specialties like ortho surgeons, they're doing appendicectomy, or urologists doing section, or OBG people doing appendicectomy, they're all they are not acceptable. So that for a safe surgery, as far as possible, don't do.
So
And
this
also,
is again for Prabhakar sir only, sir.
Yeah, that's what. So general surgeon doing hysterectomy, there see these things, certain things which are there in the syllabus again. So general surgeon can do hysterectomy and LSCS, and but the gastrosurgeon cannot do thyroidectomy because it's not thyroid is not part of the syllabus for a gastrosurgeon. And of course, MBBS, this is actually, as Pavan said, in the government, they allow MBBS people to learn certain things for especially the section and also the normal delivery also. So there are some gray areas. As Pavan said, there should not be any two laws for the same purpose. I think BAMS, it is definitely we have to consider that as quack because it will not be a modern medicine.
Shailesh sir is going to take over this slide, sir.
Yes, sir.
Hello, Shailesh sir.
Yes, sir. So this we must always take into consideration that ours is not a written law, and the safety comes into trouble for a surgeon whenever he is going against the expected type of duty, or if it is acceptable by the court defining the negligence. So he comes into trouble whenever the patient dies, either in the hospital, in the operation theater, or in the ward. And there is usually the litigation happens because of mostly because of the death of the patient. And later on, it goes on to say that whether there is a failure of treatment, proper treatment. So whatever the duty has been defined for this particular episode of treatment, that has to be followed. And the various other trouble-making things are the big bills, and the attitude of the doctor and staff, that is also covered as a vicarious liability, because usually there is some consideration where the doctor and the patient relationship has been not maintained properly. Even there has been some issues while discussing about the patient's treatment or failure of treatment. So these are all the times when the patient goes into a litigation mode. And there are certain defined people in a particular area or a town or a city where they are known to cause litigation. And of course, the reasons for this litigation and putting the person in trouble is because of the various factors. So it is always better to maintain a proper patient-doctor relationship, and also train our hospital staff to abide by the protocol whichever is being set in that particular hospital.
Sir, this is one more slide which I am going to answer: a fact of time, place, and person. Because of time constraint, we may have to go a little faster in the slides. There are 69 slides. Here I go is a direct case. Name of the case is like Madhavi versus Venkataramana. Here principle is while opining, the opinion body, NMC opinion body, additionally, the facts such as available facility, transport, best possible action, etc. are also considered. For example, there was a question, LSCS can be done by a general surgeon or not. Actually, if it is there in the syllabus, there is no question like bolums will fail. If it is there in the syllabus, there is one more gynecologist there with you, or a obstetrician is there with you. Still, you cannot be snatched, and as per the Article 19 of Constitution of India, which gives the right, and Article 21, which gives the freedom to practice. So in that way, the Bolam's opinion, sometimes the body will opine contra. And in Bolam's opinion also, hysterectomy cannot be given the liberty to general surgeon. Recent syllabus has been modified recently. Whereas those people who have got the syllabus, they can continue doing it. Whereas the opining body will always consider the facilities, especially the time, place, person, and transport, and the best possible action in each case. Sometimes that case may not be punished. Sometimes that same case may be punished. Now, Madam is going to take over here. Higher bills, courts observe. So, Vani Madam, please.
Yeah, basically, here in this, when it comes to bills, especially like in this particular case, the hospitals, the bills and everything goes in favor of what kind of facilities they have. Right. So the corporate hospitals and specialists, as might be expected, they have a higher facility, and so the bill will be high. And so the claim will also be correspondingly, compensation what they will claim will be much higher. That is what is basically discussed. Harsha can throw more light on what the legal aspect of this.
Actually, the equality before law is okay. One surgeon has done a mistake in one place like Harapanahalli, and another surgeon has done a mistake in place like Bangalore. The bills taken at Bangalore is 2 lakhs, and the bills taken at my place maybe 50,000 rupees. Then the compensation will also have the impact, because impact will be the standard of care expected at the corporate hospitals and also in the higher cities, and with the multiple specialists availability is higher. And definitely the compensation will be awarded in higher, for sometimes 5 crores, 6 crores, like that. Whereas in smaller hospitals, smaller bills, or some charity hospitals, usually compensation will be different. So the angle of court has to be observed in this case. So next, coming on to this one, Pavankumar sir is going to put a light on 304A.
Yeah, this is an important judgment in our country. That is 304A. That is in Jacobs Matthews case. Impugned FIR instituted by the police is in incomplete disregard to the directions given by the Supreme Court in Jacobs Matthews case, as also in Lalit Kumari's case, as the same was instituted straight away by the police on receipt of information regarding a cognizable offense under Section 304 of the Code, without holding any preliminary inquiry and obtaining an independent and competent medical opinion for the doctor. It simply says that no police can book a case under 304A and arrest any medical professional unless he has had a medical opinion, expert medical opinion. That is, there is an SOP which most of you have seen in your KSCASI groups, which has recently been forwarded. So that is all.
Vani Madam will take over for that referral and threatening of patients. There is a case law.
Yeah, usually, like in the sense, a doctor cannot say that you have to go to this particular referral doctor only. Otherwise, I mean, this will happen and that will happen. A kind of. You told me something, Chandra? Okay. So here the doctor is not expected to make, I mean, we should not scare the patient by saying that if you go to this person, then your treatment is done. If you go to the other person, it will not be done. That this actually amounts to kind of favoring your own colleagues or your own friends. And so trying to, divide the, what to say, their professional fee.
Madam, if I add a word.
Yeah.
We refer the patient in a to a wrong doctor.
Wrong
also
doctor
it is negligible.
Also is, yes.
It's negligible. For example, if a thyroidectomy case is referred to a urologist, a thyroidectomy case is referred to a gastrosurgeon. Otherwise, a hysterectomy case
totally to the wrong specialty.
Yeah, then also we are held responsible, provided we know it. Like we know intentionally we have done it. and we can't just scare them. That is the meaning of it.
Yes,
So
yes.
compensate as if total restoration. Madam is going to explain this slide.
Here again, the grant of compensation will be involving the entire accident. It should be within the realm of the law. And again, it should provide the person, they will claim for the entire damage. And as the sum which would be, put in the same position, like what will happen if the patient did not go and for the prolonged amount of stay, and the loss of pay for him, everything should be compensated in this.
In this case, madam,
The
actually,
multiplication and some multiplication is there.
Here, if a person of 25-year age or some CEO of some company who is earning some 2 lakhs per month dies, if he is 30-year-old and 2 lakhs per month dies, then his total time, like life table is taken up to 70
Up to
years.
60,
Is,
70, is it? Okay.
Yeah, it is multiplied into 12 into 2 lakhs, and then that amount will be granted to him.
Granted.
This is what the meaning of this judgment. And that is how, so that is why sometimes we were asking for capping, but that is not available in Indian law. So capping of compensation is not allowed, but we have to be careful while which profession is doing and what is the person, if he dies, what will be the impact. So we have to be, before only taking the case, we should be very careful, because that case, what is his profession, or sometimes we can take a declaration form from them. Declaration and average income per year we can take. That can be a defense document, because otherwise you don't know. And that fellow is some CEO of some big company, and he has the last 3 years he has earned some 1 crore or something. Then the compensation will be huge. So
it is even worse if he is earning something like 10 lakhs per month. Also, they earn a lot of these people. And yes, even in your lifetime, you would not have earned so much. You cannot compensate at all.
Yes.
This,
the Prabhakar sir is going to take over this slide.
Yeah, the false specialist board. So I have seen actually, especially in the physicians, they will put as cardiologist, nephrologist. Yeah, they've done actually only MD, but they in their letterhead usually they'll write cardiologist like that. So that is again it is not correct. And even the NMC has got a schedule of what are the degrees. Only those things you have to follow. Otherwise, there is a breach in the this thing. So because otherwise it will amount to be negligence, because the duty of care, when the patient comes to you, you should know whether you can treat or not. So unless you are specialized in that, you have to decide whether you can treat or not. So once you admit, then the second thing comes, whether what type of treatment this patient I can give. So whether it is surgery or medical line of treatment. Then what is the type of treatment you are going to give, whether what type of injection you are going to give, or what is the so if there is any breach in these things, it will amount to be negligence. So that's why whenever you are putting your this thing, you should be very careful. You have to clearly mention that what is your specialization. So if I done MBBS MS, means MBBS MS only as a general surgeon. So unnecessarily don't write I'm a cardiothoracic surgeon. So these things in the law, it is it amounts to a negligence.
If I clarify a little more, sir. Yeah. Actually, degree, what is the NMC schedule says degree, that degree only we have to put in front of our names. For example, a MD general medicine fellow who is trained in cardiology, intensive cardiology, something, invasive cardiology, something, he can write as trained in invasive cardiology. Otherwise, trained in non-invasive cardiology, he can practice cardiology. Because that, why he can practice cardiology? Because he cannot claim as cardiologist. So outstandingly open board, if he claims as cardiologist, patient may be misguided. But he mentions himself as a general physician. Along with it, that trained in cardiology, he can mention. Why? Because he is trained in cardiology. There is a certificate course. Otherwise, he has worked in cardiology for more than 6 months, 1 year, 2 years. After that, his syllabus also covers the cardiology. So in that sense, the articles of Constitution also gives him a right to practice, but he cannot just simply he cannot put a board that he is cardiologist, because he is NMC not recognized, whereas he is trained. That is what the thin line between them. if he treats a cardiac case, we cannot stop him from treating a cardiac case. Only thing is, his board says that he is trained in cardiology and patient himself has walked in. Whereas in case he puts a cardiologist as a board and something goes wrong, then that board, photo of that board itself can be a negligence. That is the meaning of
And
this
even in the
slide.
suffix also, you should not use other than what you have done.
Yes, sir. And coming on to superposing syllabus and degrees, I will be taking this slide. There are words within the syllabus, what we see, and there are words and the logbooks which should follow the syllabus. There should not be a logbook which cannot follow the syllabus. So logbook, it is not mentioned, syllabus it is not mentioned, and you are rating the logbooks means it is again illegal because that cannot be considered as a true evidence. And in under Bolam's opinion also, wherever you are in trouble, when surgeon is in trouble, he has to submit some copies to the opinion body where he has to put his logbooks, which are also parallel with this syllabus, and syllabus copy also he should submit. That is what the meaning of this slide, sir. Here, Pavankumar sir is going to. Actually, recently he has actually presented moderated a session. In that it was there. Sir Pavankumar sir.
Pavan is muted actually.
Sir, in case of minimal.
Yes, sir. Minimal office standards, that is what all has to be displayed is very important. Display should be on the waiting areas, not in your own chambers. Especially the registration of your establishment has to be displayed. Then display of patient charters and doctor's charters also you can display. You can display on the facilities available in your hospitals. You can display the safety norms like fire, biomedical waste, all those things, signages should be there. And certifications of all these like KPMA, PCPNDT, MTP, and all the insurance which you have empaneled should be displayed. The certificate display is very mandatory. It is not mandatory, but it makes the life of yourself and the officials who are visiting your center easy, so that they don't trouble you and they don't wait to get those certificates from your side.
Sir, in case a doctor is stuck in negligence case, even expert body visits this clinic.
Okay.
And they will check all these things like equipments, especially OT norms, SU norms, and fire norms, and KPMA registration and all those things. So the actually the people who are actually watching us should know that the expert body visits the clinic. That is also very important.
Yes.
And next, coming on to this, sir, minimal business standards, actually the PF, ESI, labor laws and taxes, even doctor can be in trouble sometimes without doing these things. This is just a compliance slide is good. And coming on to this, Shailesh sir is going to explain documents and records.
Yes, sir.
And Kalaivani madam also can add up something.
Documentation.
Yes, sir.
Yes.
You start, sir.
Yes, ma'am. Documentation has to start the moment the patient enters your hospital or the clinic. And this is important in all steps till the patient gets admitted and till he gets discharged and he goes home with a discharge summary. Because whatever written is done and whatever not written is not done. That is, whatever you write in your records or the documents, it means that you have done it. If it is not written, it is considered not done. This assumes importance because once if there is a litigation, these case sheets and the records will be definitely checked. And if it is not written, it is considered that you have not done it. So wherever you write the notes, it has to match with the other notes in the hospital. And there has to be proper guidelines and proper protocol has to be followed. Even if you write, if you can see, there are so many hospitals or the colleges, they write CST. It was asked in one of the courts, what is the CST, whether it is Chhatrapati Shivaji terminus. This is very commonly followed. I'm just pointing out the things which can be considered there. So that becomes very difficult for you to explain when you are in the court. So that's why it's always better to maintain these documents and the records in a proper way in your hospital.
Yeah. To add to this, Harsha, the few other things when you write any kind of document in your case sheet or wherever, first thing is the date and time has to be mentioned. The date and time of your examination, whatever, has to be mentioned. And it is seen by whom also should be mentioned in capital letters, it is said. And the treatment part again should be written in capital letters in your, when you're writing your daily notes in the follow-up sheet. It should be mentioned in the capital letters only. So just to quote one example for that, I was remembering a patient when we were on rounds, we found the patient was normal. Then after some time, we finished the rounds and we came back to just have a look at the patient. He was in an unconscious state. Why this happened was, we just inquired with the sister what exactly happened. She said, I gave insulin and after that patient is like this. How much insulin you gave? She gave 60 units of insulin. Why 60 units? Because it was actually written 6U. 6U, and this was looking like 60. So patient sister has given 60 units of insulin. So that is why documentation on the file is very, very important, and the legibility and clarity in which we document is very important.
So Shailesh sir is going to talk about some consents in
This is a
brief.
very important topic about consent, and there are various ambiguity things in this chapter of consent. There are various types of consent, as the implied consent, that he comes to your hospital. It means it is implied that he has given a consent, he is coming. There are oral consents, and the best thing is to have an informed written consent. Proxy consent, it is not valid, and there have been so many proxy consents cases where the judgment has gone against the doctor or the hospital. And this proxy, it becomes invalid even if the patient is unconscious. And it's valid only if the patient is a minor or is of unsound mind. So that informed written consent is very important. Why consent is important is, if you have taken a consent, the doctor, the judge there, he just keeps the consent form or the consent papers aside. If you're not taken a consent, you will be in a hot soup. That is why consent forms are very important. There is a lot of prejudiced discussion about how should be a consent form. And there are various things which can be discussed at length, but it is best to have a written consent apart from your printed consent. And there should be different areas wherein you need to have at least 2-3 lines to fill up the forms. And some courts, they ask for consents in your local language or the vernacular language. Even that can be added to your consent form. That becomes mandatory because it means that patient has understood that what he is signing for. And never make sure that the patient signs in front of the doctor itself, and never allow the nursing staff for somebody to take the consent. Or at least you should have explained the contents of the consent form, and then the patient and the attendant should be able to sign after understanding what he has been informed. So that explains the informed written consent.
Madam is going to
but to accept consent now of late, if I remember, they're preferring even the audio visual of
yes,
the consent.
Audio consent also.
Audio consent
audio
is
visual also.
Madam, audio visual is compulsory in organ transplant. Nothing
yes,
else. No,
organ transplant.
Not anywhere.
The act itself.
Organ transplant.
It is
Actually,
not compulsory, sir. It is safer. It is said.
Yeah, it is safer, madam. Safer,
safer
not practical.
any day.
Not practical,
And,
but consent per se, madam. Actually, consent per se is a written informed consent where the party, both of them, should agree. It's like contract, madam. It is not a simple word. It is a contract. Whenever we go into a contract, for example, we go into a contract for something like you want to go for a contract for your hospital construction. How will you go? You ask everything. No? We ask for flooring. We ask for painting. Or similarly, each word is mentioned in the contract. Similarly, consent is, each word should be mentioned in the consent. Say like what you are doing, and consent or not single consent is always consents, because when we are doing appendicectomy, you are going to do a bowel resection, then you need an additional consent. And at least if not the patient, at least the first degree relative should give the additional consent. Such things, like it's a very practically easily understandable. We neglect this, and majority, more than 80% of the cases we have lost in the court just because of consent. It is not because of Boehm's test. NMC usually favors a doctor. Even court tries to favor a doctor, but only problem is when we do not have a consent, the opposite counsel will be very easy. He wants to first strike off the consent part, where consent is not a proper agreement. So consent should be stressed because it is not very important for the treatment sake, but it is very important for the legal sake, where that is the only defense which is going to save us in the court of law, where lots of cases we have lost based on consent only.
Consent. that
Yes.
should include all the complications of that particular surgery wherein the gap is left according to the NMC regulation, where there may be a common platform, common protocol, but gaps should be left to add specific complications which has to be mentioned. Now of late they're also saying that we have to include what percentage of complication also has to be mentioned in order to be safe, and it has to be taken by the operating surgeon or the person who's assisting the surgeon.
So regarding
Anything else,
bills
Harsha?
and regarding dead body disposal, actually, madam, your turn is this. This is a case.
Yeah. According to this, if there is a death, the hospital or the institution, whatever it is, they cannot hold back the body saying that bill is not. They have to hand over. So they cannot say, okay, bill is not paid, so we will not hand over. So this again becomes punishable for the institution or the hospital.
The question is how to recover is we can recover using a civil suit if they do not pay. Otherwise, we have to recover through a request or something. Recovery can be done. Otherwise, we have to recover through. But we cannot keep
Hold the body.
Hold the body.
Harsha, can I add here?
Yes, sir.
Yeah, the best solution is, as you said, that is through litigation suit and other things. But best practice for all the surgeons or those who are dealing with critical care is to keep on collecting advances, so that at the end of the either death or discharge, you should always be left out with only 20% of the billed amount.
Exactly
so
right,
it will not be under problem. And
Yes.
litigations for claiming of these bills is possible only in a bigger city or not in a smaller city. It gives a
Yes,
very
sir.
wrong notion to the public also. So best practice is to collect frequent advances, not as a lump sum, frequent advances as and how.
Sir, otherwise also in death cases, we should be little liberal, sir.
Yeah, that is true. Even if you are foregoing your last 20%, that should not be a problem for your treating.
And Shailesh sir is going to talk on art of communication.
Harsha, I just want you to add a point on this. In case there is a death and you simply waive off your
Bills.
charges, patients parties sometimes they also think that the hospital or the doctor has done a mistake and so they're waiving off my charge. This also has we have come across.
So we have to be careful on both the edges, madam.
Yeah. Yes, we have to. So it's better what Dr. Pavan said will be better to keep collecting some small advances every now and then. Otherwise, even if we have done the right thing, we are in trouble.
Shailesh sir, any special point on art of communication? Any special
Sir, I
point?
just want to mention, sir, we need to be very good at this, and we learn it by committing a lot of mistakes, because communicating is a two-way skill, and it also includes listening to what the patient is telling about it. And patient requires basically clarity, empathy, and you are hearing to them. Most of the times it so happens that we are so stressed with so much of work being done, and we don't listen to what they are telling. And we must develop this art, and this can be taught also. This can be taught to students who come into medical colleges. And I think the recent NMC makes it a point to consider this art of communicating as a subject itself. Because in our days, we were never being taught. We were never even asked to communicate and being observed. And in the European countries, we have a different format of communicating, sir.
If I add one more point, sir, where societal position where we have to participate in some of the community works, like something like, we have to be there with them. For example, if they are going for some some of the important things like some water problems or sometimes some school programs, such things, doctors have to participate. Doctors try to avoid social connections and they try to avoid elections. They try to avoid such things. So they should also come in the front line.
Yes,
not only elections, so socially they should come in front line. Politically also they should come in front line.
It has been observed that whoever communicates and has this touch with the society and the crowd or the civil crowd, they definitely do well, sir. You can see this, you can compare even in some cities like ours, where the seniors and the juniors, there's a lot of difference. Seniors are so well connected to the
society.
Public, to the society.
And the litigation will be very minimal.
Very less, sir. Very less.
Nothing.
And whenever there is
even something goes wrong also, there will be no litigation at all.
Correct.
Yes, sir. Now, Sir Prabhakar sir will take.
Sir, Yeah,
Broad date,
this
broad date.
MLC medical legal case is very important because most of the times we will believe the patient's words, and if we don't intimate the police, so whatever it may be, the patient may say it's a self-fall, but you have to intimate, because if you don't intimate and you are hiding the evidence, so that's what the law says. So usually you have to intimate, and of course
Nil MLC is wrong, sir. Nil MLC we cannot write.
you cannot
Yeah.
write.
Now it is not accepted.
Can I add here, sir?
Yes, sir.
Simple and best practice is to keep the email IDs of your town police or whatever police station your establishment comes under, and just send them the intimation through email. Many times it will be difficult in the night hours to send one of your persons to the police station. The email intimation is more than enough. And the further proceedings is left to the police whether they want to continue this case or not case. But you have intimated and you have the documentation for that in your emails. So that
Yes,
is
sir. Shailesh sir will be taking for vicarious liability and non-qualified staff indemnity.
Yes, sir. Sir, being a head of the team, it is always important that a doctor is being considered as responsible for all the mistakes being done by your staff. So it becomes important in this way that the staff who are employed by you, if they mistakes, then you are responsible for their mistakes. So this could be the duty doctors, this could be your assistant in the OT or the nursing staff, or even the watchman, the electrician, plumber. That is because the same vicarious liability, if there is a blast of the AC and the fire in your ICU, you are liable for that, even though it was the fault of somebody else. So this becomes very important, that you have to maintain various departments in your hospital, and you should be always having a proper documentation of your staff's qualification. It's always better to have a qualified staff. According to their qualifications, you can be registered under various sections of the government as well as the non-government things. And fire accident.
Sir, practical safety is many places there are non-qualified staff we have observed.
Yes.
So even they have signed, they have done all the writing work and all those things, then also the indemnity will cover it, because unless it is a criminal case, the civil suit will be covered by indemnity, like insurance indemnity will cover. So that is the point which I wanted to stress, sir, because doctors will not be knowing. This rider has to be taken, especially whenever we take a indemnity, medical insurance.
But sir, indemnity, if there is a non-qualified staff, it won't be applicable, sir.
It is, they have a rider, sir. Recently, they have put on a rider, they will cover the non-qualified staff also. Except criminal
they need to be registered somewhere they need to be registered, sir. Even if they are non-qualified, they don't.
In the hospital itself, they will be in the register, sir. They will be in the register, PF register or something. They will be there.
That's
so.
What,
So when the doctor is on leave, madam has to enlighten us on this one. Safety rules.
When a doctor is on leave, he has
immediate
to
post-op, madam. Next day, post-op.
Yeah, he has to hand over to a person who will be equally responsible to take care of the person, and this has to be also informed to the patient, and it has to be documented that he will be on leave, and in his absence, so and so will be taking care of the patient, or it
Documented.
can be documented. Document should be there that in his absence, so and so, this doctor with this equal qualification will be taking care of this patient, and this document is a must, whether he's going on a long leave or short leave or absence. Even if he has appointments and if he has to cancel, he has to make a document that he is not available on this particular day, and this has to be conveyed and documented.
And again, this slide is for you only, madam.
Institution and group practice. Again, here institution and group practice in institutions, even though it is going to be a group practice, but still the vicarious liability again comes to the unit chief in a medical college. So that is what we were discussing about the vicarious liability. End of the day, again, it is coming on to this. You have to throw some light if a junior is operating and
Madam,
in the
For
Yeah.
a safe and long run for junior surgeons,
Huh.
actually they should create like a good harmonious group within the town where they are practicing. That is the very important thing here, madam. Thing is, if they are in institution, also they have to have a good rapport with the other doctors, because once they are called for some help, they have to come and help them out, and also they have to come and write the notes there. See, if you are in trouble, if you have got a good doctors there, group practice includes that a doctor is there to come and help you out, then the question of criminal negligence will go.
Correct.
So that is a safe
is,
service.
that is
what
in
the
one of
advantage
the
here.
cases which you discussed where nephrologist was not available. That was the case you discussed in one of
Prabhakar
the
sir will be-
previous.
Yeah.
Prabhakar sir, checklists.
Checklist. Actually, the safe surgical practice, any surgeon, especially before doing any surgery, of course, we will take all the precautions. We will investigate and what are the things we have to do and all. And the WHO guidelines for the checklist for the surgery we have to follow. That is, before giving anesthesia, we have to check whether the oxygen is there or other equipments are there, and what are the equipments you have taken for surgery and all. And before putting incision also, you have to check once again that the patient is correct, is the same patient or the different patient, or the site. You have to see whether the correct site you are operating or not. So this you already checked, but verbally you have to communicate with the sister that whether we are doing correct thing or not. And then after surgery also, before shifting the patient, you have to once again you have to see the checklist and the counts of the mops or the gauze piece or even the instruments, and whether the tourniquet you have applied, all those things, safety measures you have to take to get a better outcome of the surgery.
Sir, this slide also goes to you only, sir. Prabhakar sir.
Yeah. So invariably, in spite of all taking all these checklist or even the safety measures, sometimes we may err in some problems. So definitely, in case if you are guilty, then there is professional indemnity will help you, especially because for the highest compensations and all. Immediately, it is very difficult this thing. So even our Indian Medical Association has got very good indemnity this thing for the doctors. So I think it is better to become a member for the IMA KPPS. So that's almost to the 1 crore compensation, up to 1 crore compensation is there. So it is not only for this, even for the institutional indemnities also is always better to have if they are running any institution.
So negligence part also from your side only, sir.
So negligence means that there are negligence is there for anybody, but in the professional negligence is little different. So if there is usually one surgeon, if you are supposed to do follow one protocol, and if he has not done or he has not followed the protocol, say by act of commission or act of omission. Say, for example, act of commission, usually the surgeons will close abdomen without leaving any equipments or any gauze piece like that. If you have left and you have closed, so that is a negligence. So that is act of omission. Act of omission means usually if you are you are administering some drug which is the patient is allergic to that, and you know that, and if you have not given any test dose before administering that drug, so that is act of omission. So these things there is, then we call it as negligence. So of course the negligence will be I think Harsha will enlighten any further this thing.
Further slides will come, sir. We'll go ahead, sir.
Okay.
And here again, Pavankumar sir is going to talk on this, sir. Pavankumar sir.
Yeah. Patient claims a damage to coat, that is Boehm's test, which says should be qualified. And as Dr. Prabhakar sir was telling, Boehm's test is on the mainly it is expert opinion, both in civil and criminal negligence. Expert opinion like a body found by the district level authorities of all the specialities concerned with that case, or one of the expert bodies is again the medical council bodies. Court will ask the experts to put all the material, which led to this opinion. Court may reject the expert opinion also in some cases, but most of the times Boehm's test is uplifted. Yeah.
Actually, in Bolito, you need expert opinion also. I mean, there will be two schools of thoughts. So if you have followed any of them, then you will be safe.
Yes.
So regarding legal process, Prabhakar sir will be talking, sir.
Legal process, actually, the civil law, usually was what I already mentioned, that civil law usually, if there is any breach in whatever the protocols you have followed, you are supposed to follow, so then it will be here. There are two laws. One is civil law and the criminal law. So the amount of negligence usually we call it as civil law. If the degree of negligence is very high, then usually it comes under the criminal law. So majority of these things usually they will come under civil law only. But if the negligence is causing any damage, which is in high this thing, so usually it will come under criminal law.
Sir, in this slide, regarding legal angle, law is directly opined without, law has directly taken a decision without even taking the Boehm's test or other expert body opinion, where the hospital treated a typhoid fever by giving medication instead of giving medication for malaria fever. So res ipsa loquitur is applied. Similarly, when we leave a mop inside, some scissors inside, same thing will apply. That's what the legal angle, direct angle, where without any opinion, even court can punish sometimes. The complaint of negligence, actually, I would like to enlighten. The complaint can reach the SHO of the station, then AC, DC, Judicial Minister, MLA, THO, DHO, Human Rights, KMC, NMC, Civil, Criminal, Suit, and Press. So, doctor should not be very much like all the whatever the notices receiving from all these people. He should be very calm and cool, because it's such a emotional thing, and also doctors are so much worried about their image and all. So we should be little bit careless in facing such kind of things. All shall have to take expert opinion, but Boehm's test is a mandatory for all of them. You see, whoever comes, then Boehm's test has, we have to answer a single word that let it go for expert opinion. I am right. This is one single word. So media also shall publish the incident as it only. They have to publish this, shall not opine until the authority releases reports and actions. Defamation can be claimed later if not guilty. Court may be pleaded for directions not to publish any media opinion until conclusion. See, there is a kind of thing which is there, because media will come and suddenly they will cover and they will start publishing everything, and we keep quiet. Actually, we should write to them, or otherwise we should call them and tell them that I am not negligent. If your report is defaming me on the media, then I am going to take action. So such things should be very clear. Otherwise, what happens is they will be giving judgments. So again, regarding consents, Shailesh sir is going to talk a case.
Yes, this was a case of Samira Kohli and Dr. Prabha Manchanda, where she was taken into the OT for diagnostic laparoscopy. And then they went ahead and did a hysterectomy with bilateral salping oophorectomy. This was done according to the doctor, that it was done under proper consent taken by the mother, who was standing outside the operation theater. She was explained, the mother was explained, like I was telling about the proxy consent. So this doesn't hold good in most of the cases. When you've taken a consent from the patient, who is an adult, well informed, of sound mind, you've taken a consent for diagnostic laparoscopy, you do diagnostic laparoscopy and come out. Then later, when she is conscious and later on in the ward, you can explain to her, if required, you can, with her consent, you can go ahead with this total hysterectomy and bilateral salping oophorectomy. Then it was argued that she was mother's consent was taken, the patient was unmarried, but these all went against the clinician, and then the complaint was registered, and compensation also given to the patient. So therapeutic privilege is also one factor where you can tell the court under this defense you can be acquitted. But most of the times we doctors, we have a paternalistic attitude. We think that we act like parents of the doctors, and we ourselves consider them as our children and then give the consent in all good faith, But if everything goes fine, it's fine. Otherwise, we'll have to be in the unsafe zones. So it's always better to stick to the consent, because that is the one thing which if litigation happens, that is the main thing which the court will ask for.
So there are consents for the defenses, which I will take
Yes,
up this slide. See, the section 87, IPC 88, 89, and 92 has clearly said that in good intention, we can take some of the decisions which are which are beyond the ability of the patient to decide, and the situational, like where the patient cannot give any consent for such kind, then only it is accepted. The defense is accepted only when it is explainable. Defense cannot accept, like section 88 or something cannot accept saying that in good faith I did this, because there should be a good faith. Actually, there should be a good faith. Three main defenses available. Otherwise, negligence to come out is contributory negligence defense. Sometimes patient has not told some important history. That is also a contributory. Comparative negligence defense, there is one more case law is there. I did not put it, becomes elaborative. Assumptive risk defense is there. These three case laws I will put later on. And then coming on to again one more slide, Shailesh sir, like CPA
Yes,
applies
sir.
to doctors.
Sorry to interrupt, Shailesh.
Yes.
I think so.
Yes,
We
sir.
are running out of time. We'll make this, we can cover this up in next meet. Shall we take the questions if you don't mind? Because too many
Yes, sir.
questions are there in the chat box. Let's finish them today. And the remaining part, if all of you agree, we can take it up later and after a week or so.
Sir, we have covered everything, sir. So now we can take questions.
Okay, please. That will be better, please.
Probably
Sorry, sir.
probably we'll cover all this in questions only.
Yes, madam. That will be better.
Yes.
Harsha, please go with the questions.
Sir, questions, I think I'm not getting the display here.
No, I will read
Yeah,
out.
please,
I will
please.
read out. There are a lot of questions. Many questions are there.
In the
So
chat box,
I will
it is
start
there.
with the first one. Yeah. The first question that is coming is how NMC helps doctors, from Dr. Dayananuli. Harsha, or anybody in the...
No, NMC cannot help. As I said already, the NMC is for both doctors and the same. But people think that because the NMC, the doctors are, that is why the Volumus test actually, why it is failed, because public thinks that the doctors will help this thing. But NMC will not help. It's only if you have, according to your documents, definitely it will follow the whatever the documents you have in the case sheet.
So just for the benefit of everyone, Boehm's test is nothing but take an expert opinion regarding that particular treatment or whatever the doctor has done against whom the litigation has been done. So taking an expert opinion from a person with similar qualification. Right,
See, if
Harsha?
I add on, madam, it is a peer adjudication. It is called.
Adjudication.
That is peer adjudication. That means you are judging by the same peer group.
Same
peer group of similar kind. Only thing is it is condemned, and Bolito is now on the mainstream, but Bolito is still not able to come here because India doesn't have an inquisitive law system. It has got only passive law system. So still Boehm's will run for our generations, because the Boehm in under Boehm's test, actually there will be a expert panel where they are going to check whether you are really qualified to do this, and second thing is whether you have taken proper care to do the following action. For some procedure you have done, for example, cholecystectomy you have done, whether you are really a general surgeon or not, first thing. Second thing is whether you are have taken proper steps of doing the major surgery, like pre-operative, intraoperative, post-operative care, all those things, and your competency will be judged based on that, and they will opine on accordingly. If a gynecologist has done cholecystectomy, then her degree doesn't support that, then directly she is not qualified to do it directly. Otherwise, she may take a defense of MBBS, saying that I am MBBS doctor, I know about cholecystectomy. So then what happens is the error of MBBS surgery or MBBS doing major surgery was ended in 1985. That's what the fact, what I am talking about, fact versus law, where fact of doing such thing, fact of doing MS general surgeon doing urological cases, or fact of doing craniotomies are gradually fading. We can even defend them. It's not a big thing that we can't defend them, but still it is gradually fading. So the fraternity should understand that we should give way for the other specialties to practice also. In case where there are no specialists to practice, there we can take up those specialties and also practice after getting proper training or working under someone and getting trained. So we can't put a board as urologist or a oncosurgeon. We can put a board as trained in oncosurgery, worked under oncology department, such things, and we can really practice. That is the beauty of general branches. Whereas specific branches, they have their own workload. That is how the BOLEMS is considered.
Bolito's test also you can just briefly tell what it is.
Yes, madam. Bolito is nothing but the court will reject the opinion of BOLEM and directly put it onto the Bolito will directly check whether the opinion body has really opined properly or not. When court is not satisfied with the BOLEM's opinion, it can reject the BOLEM's opinion. In India, actually, BOLEM's opinion rejection is very rare, where BOLEM's opinion is considered everywhere. Whereas in Bolito, court can directly keep it aside as a one of the contributory factor, whereas directly it can opine based on its observations. That is what Bolito, madam.
Okay, fine.
And
I think
also
now-
law expects actually it's not corporate hospital style of treatment or the PHC level of treatment. So it is in between. If it is a reasonably good practice, it usually law will accept.
So actually the qualification, otherwise syllabus, and then the standard of care. These two things will be checked in the BOLEM's test, madam.
I think now a kind of everybody is getting well versed with this. Now there is one question from Dr. Nas. An oncosurgeon, if he registers as general surgery, can he do oncosurgery?
If he's actually oncosurgeon, a general surgeon can do oncosurgery. That is the problem here. Because it's a general branch where he can get trained. Whereas oncosurgeon cannot do general surgery because that is a terminal branch where he will be operating on complicated oncosurgical cases. He should not expect himself to come back and do general surgical work, because his training and the time he has put on and dedication is to profess and master in a special branch, that is oncosurgery, where he has just gone ahead of general surgery. That doesn't mean he can practice general surgery, because I am a law graduate as well as a medical graduate. I can't practice both the professions. A Competition Act is there as a standard act, which says contradictory, where you cannot give full dedication for one branch. You have to give full dedication for a branch profession. A single branch profession, for example, general surgeon should dedicate for general surgery. Oncosurgeon should dedicate for oncosurgery. He can say that I was a general surgeon and now I am an oncosurgeon. But this clarity should be there, which is not been mentioned in the NMC Act. That's what
there is no division at all.
It's not been mentioned.
Yes.
Not been mentioned. Such case laws are also not there in the courts. But such things are very fine if medical legal consultants go to the legal profession and start practicing. Such finer things will be observed. That finer things are not observed yet in the court cases. But this is what the position in general law. What I am talking, not medical legal law, general law, where profession is considered in Article 19 and also Article 30. Yes, ma'am. Any more questions?
Just there are lots of questions. You can just answer this in one line. Can urologists do hernias? Is it legal or not?
His syllabus includes hernias, madam. His syllabus has got urology syllabus has got hernias.
So they can
we can open and see their urology syllabus. They can do hernias. So cholecystectomy is not there. Hernias is there. Recently we had one discussion with one of the urologists, and they submitted the urology this one curriculum. Actually, one of the university has hernias and other university did not have. So the university which does, that is why University Act I mentioned 1958, which is very important. Universities are very important because each degree which may be mentioned as MS or MCH is different, because each MS may not comprehend with the same syllabus. Sometimes the syllabus of Mysore Medical College is different, syllabus of Kuvempu University is different, presently syllabus of RGHS is different, and NMC syllabus recommendation is different. So in which year you are passed out and what are your rights? The rights according to Article 19 of Constitution 1 Section G, they are like inclusive of your syllabus, what you have read and what you are trained, what your logbook speaks. So for a urologist to say that I can do a hernia surgery, is urology curriculum should include hernia as a part of the training. Already he is a general surgeon who is trained in hernia surgeries, but when he registers his MCH urology, his general surgery degree goes into incubation. So MCH urology surgeon is professed to do urological cases. He cannot look back as say that has got mine, but he should see his syllabus. So if his syllabus still has got cholecystectomy, for example, he can do cholecystectomy. Nobody can stop him doing it because it is comes under Article 19.
So
But
I
if
think
it is not, yeah,
this is answering also the subsequent questions, which says gynecologist doing inguinal herniaplasty. It is not, it cannot be done.
Cannot be done because if you check their syllabus, it is not there.
It is not there. Okay, so that answers the next few questions. And what happens with the government promoting Ayush and allowing Ayurveda doctors to operate?
For this particular question, actually, Prabhakar sir wanted to answer because one of our slides has got the provision for it, because NMC has provisions at 2 points. I think section 50 and section 42 or 36 has given a bridge course. There is an option for bridge course. So if option for bridge course is done 6 months and government gives a notification, government is supreme authority. If it runs an act based on NMC Act, NMC Sub Act, and then bridges between allopathy and Ayurveda, and if it issues a license, definitely they can do it, because government is a supreme authority, which is an elected body by the people, for the people. They can take a decision, but they should take a decision in a proper manner. They should take opinion of stakeholders. Second thing is they should have a provision, and that is why they have included NMC Act. They are very smart, so they have included in NMC Act.
But
Now
NMC also
They have not
says
taken the opinion of the stakeholders. That is the biggest problem.
yeah. No, but NMC also says you cannot do, you
That's
cannot
what.
practice other
Yeah.
type of medicine. No other pathis except your own pathi. It says.
But government intention is to make more number of doctors, because health should become their priority and health should be easily available to everyone, because we are trying to hold the health for allopathic doctors. For example, ultrasound should not be done by an this one Ayurvedic doctor. Judgments are there. Then how to overcome those judgments means the government will find a loophole. How they will find a loophole? They will include it in the NMC Act. Then they will pass an order. And after that, they will prepare one training session. Then after that, they will give a certificate. Then inside the court hall, they cannot challenge it because it is there in the Act. Act cannot be challenged in the court of law. So because it is an Act, because it is passed. So that is what the loopholes mean.
There are many loopholes, and there are many things that actually troubles us. In
the government
that case,
can do it. Government can do it. That is the answer for it.
Can I add here?
Yeah, Dr. Pavan, please.
See, any law for that matter, madam, has loopholes for the government and loophole for us.
For us also, correct.
So it is better that we read the laws and use appropriately when required.
Madam, one thing.
For ourselves.
Whatever, I don't deny whatever Harsha sir said, that a urologist cannot do lap cholecystectomy and other things. But if he is able to prove his efficiency in doing a lap cholecystectomy, and he has followed all the steps what a general surgeon or a laparoscopic surgeon has done, no court can award him any. And if the complication or whatever has happened is in terms with the accepted complications, no court can award him any compensations, provided he has fought it in a right way.
Venkatachala was telling something.
So rules are meant to be broken. That is the problem. Unfortunately, everywhere, whatever level, no, in medical, non-medical, rules are meant to be broken. But you should be practice safe. Safe practice is the key. That's all. So I am an oncosurgeon. I do everything from head to toe. There are certain benign cases where I am called to operate because others cannot do. But they're like, if hysterectomy has to be done, they involve me also sometimes with the gynecologists because of the difficulty. Ultimately, if you are within the limits, you should read the law, read the guidelines of NMC as circulated, and practice safely. Safe practice, everything, whatever Dr. Lakshman used to say, documentation, communication of the documentation, and documentation of the communication.
Include gynecologist will be the safest way, sir.
Correct. Always. I involve, if I am doing benign laparoscopic hysterectomy, I call one of our gynecologists. They call me if they need. So that is how.
Group practice, safe group practice.
Yes, practice. Like if they say appendicectomy, I cannot do. I do appendicectomies in cytoreductive surgery, ovarian tumors everywhere. So that is part of, there was no defined syllabus when we did MCS 22 years ago.
So winning a case depends on how well you argue your case, Harsha.
Correct. No. Like in your consent form, madam, we have everything mentioned what I am going to do. Cholecystectomy is done in cytoreductive surgery because gallstones are a big problem to manage there later. Invariably, gallstones happen. And we do appendicectomy. So we mention it, explain it, draw, and always video consent will save you more than your written.
Yes, that's what I was telling.
Video
Especially
consent is the rule. No, whether
the
you like it or not, please record and keep it in your mobile phone. That will help.
I would like to add here, sir. It's an alternative, but not an replacement.
Mandatory.
Consent.
Sir, the only advantage in video consent is they cannot deny that you have not told.
It's not mandatory.
Very true, but it's not an alternative for written consent.
Correct, sir. But
As of present law,
court will always see whether you have
Yes,
made
yes.
a reasonable attempt to communicate.
Definitely.
Patient will not understand everything, but you have communicated.
Definitely.
The only thing is when you have done video consents, you can't add anything because some peculiar complication has happened means that thing is not spoken, and those when we convert it into audio record,
You are in trouble.
So
then
there is
we are
video.
in trouble because it's a double-edged sword. Because unless you know what all to be disclosed and what all to be documented, and unless you know everything, the consent itself may be an opposite weapon for us, because lawyers are very smart. See,
Lawyers will know. Lawyers will know where you do mistake. They will go
That's
to
what,
those
sir.
points. Lawyer will go and take opinion of 5 doctors. He will take opinion of 5 lawyers.
Again,
Minimistic documentation is always
it's an
important.
intelligence of presenting whether to the video conferencing in case you have missed it.
Sir,
So-
what happens here is video consent is for our record. There
Yeah.
is always a written consent. I have 50 consent forms for each surgery. In every complication is mentioned, including risk of COVID infection. So that is there. Each hepatectomy means separate consent form. Sometimes 5 consent forms for one surgery. So that is how we practice.
Average
We
3
learn
should be
charge.
taken, sir. Minimum
That is all.
3 consent forms should be taken. Minimum.
So I have iris consent, major surgery consent, staging laparotomy, cholecystectomy, ileostomy, everything.
Whether we have told or not, the consents will be taken. Majority of the hospitals.
Documentation matters more in the court. Whether you have communicated or not, that should be documented.
Dr. Venkat,
Yes, sir.
I think so. The discussion is going in a different way. I
Yes,
request
Siddesh sir want to
Kalaivani
talk.
madam to please just
No,
go
no,
with
no.
the questions.
Dr. Siddesh is saying something, sir.
Sir, we'll take the questions later, sir. We have a lot of questions in the chat box. Let's finish that.
Yeah.
Sorry, sir.
No. I joined in late. I didn't
Yes, sir.
know. Anyway, go on.
Yes, sir.
Sir, Dr. Shanta Patil and Dr. Rajgopal Chennai, sir, both your questions are again similar to what was answered by Dr. Harsha, that if it was there in your syllabus during that time, it is accepted. Agreed, Harsha?
Yes, sir.
Yeah. The next question is, what about referral fee and cut practice? Well, that is not at all accepted as per the NMC regulation
Actually,
act.
practically all are doing it, madam. But the on document, if somebody is caught, they are in.
Yeah, because it is not accepted. Okay.
Not
and
accepted, but
not
majority of the
accepted.
doctors are doing it.
It's clearly mentioned in medical ethics.
95% are doing.
Yeah, but it is
Kalaivani,
not
can
ethical. It is not ethical. It's not accepted also.
It's clearly mentioned
Kalaivani, can I
in
come in?
medical ethics.
95% of people are doing this. You know,
We are
it
recording
becomes
this,
very
Dr.
difficult
Ravi.
for the 5%.
We are
Yeah, I
recording
know.
this.
But it is
And-
true. Only
Yes,
5% are not doing it, and we are in difficult distress because of that.
Association
It's-
should take a call.
Yes, that's all. But it is,
Sir,
as per
let's
NMC
not
Act, it's
dispute
not
the-
accepted.
Let's not dispute the laws. I request we'll go to the next question, please.
Yeah. Then is a written consent for grave risk or on-table death consent helpful in case of legality? Is a question here.
On table death consent, we can't take, madam. We can explain that there is a chance of on table death in very rare cases. Usually on table death possibility cases should not be operated as per the current legal practice. Because such things will be very troublesome to the surgeon if patient parties become hostile. So what my suggestion is, we can't agree to kill. We can't contract to kill someone. Like that is the meaning of it. See, you can't have a contract to kill. So same thing happens. Okay.
But
that
ASA
is-
grade 5.
Grade 5, when we operate, the chances of death are so much, like we can mention and take such cases, juniors should avoid doing such cases. The seniors can do, institutions can do, but better private practice and single man practice, they should not do such cases. That's what the advice, but they can do, of course, the grave risk we can take, and we can take death risk and we can mention it and do it. But for a safety reason, such cases should be avoided. One in some like rarely they come in 6 months or something. Just refer him, just stabilize him and refer him.
Okay, to
You
answer the
mentioned
question,
in the grave is the possibility of death.
but to answer the question, sir, taking a grave risk consent or whatever, if you're explaining about the death, that doesn't make you immune against any litigation or filing you for civil or criminal negligence.
But
So
can you
that-
defend?
Always kept in
No, you
mind.
can't defend. That's what they
No, that
both
is not
have.
defend.
Yes,
This
you
cannot
cannot
be.
defend. That's the final conclusion. And who can give fitness for surgery, physician or cardiologist? Dr. Pavan
Surgeon.
Patil has answered, it's anesthetist.
Surgeon has to be a doctor, physician first to assess the patient.
No,
No,
why?
sir, legally, let us talk on
there
that.
there is nothing called as physician
Legally,
fitness.
there is nothing.
Exactly.
Sorry.
Okay.
It is the PAC. Why physician fitnesses are taken is we as surgeons fail to identify some unhidden problems of the hidden problems of the patients. So we tend to pass on it to the physicians, or most of the time anesthetists ask for physician fitness. So
Okay.
he has done a PAC and he opines, it has to be documented that he wants an cardiologist opinion or a physician.
Dr. Pavan has already answered that. Thank you. And here, can general surgeon claim to be a laparoscopic surgeon if he has certificate from IAGS or other similar organization?
Definitely can claim, madam.
Yes, we
Because-
can, because it is a part of the syllabus.
Yeah, organizational position is also been explained in the NMC. NMC also gives provision for organizations, and also it gives elaboration for example, laparoscopy was not at all there in 80s. Even the word laparoscopy was not there in 70s. So those surgeons, after getting trained, they get their certification. That is what peer certification. This is called
Yeah.
peer certification.
Yes,
Same
yes.
peer adjudication, peer certification.
And
So
also
peer-
the continuous CPM, the continuous, what is it? Professional development, CPD.
CPD.
Yeah.
CPD is also important, madam. CPD collection of points are important. Attending of conferences is important. Documentation in logbooks are important. They are all defenses. They are going to save us.
Yes.
Sometimes
So,
if we are doing something, they are going to save us.
so with this kind of degree, it can be done because it is part of the syllabus and it is also part of continuous professional development.
If it is there in the syllabus, it is really high, very high degree of defense, madam.
Yeah, laparoscopy is there,
Yeah.
endoscopy
If it
also
is-
is there in the
if it is
syllabus.
not there, if it is not there in the syllabus, then also it can be claimed. Only thing is a peer certification should be done. After that, again, you should have logbook practice.
However, that FIAGS is not an accepted degree by NMC. It
Yeah,
is just
but
an additional training.
Additional training. You can
Yes.
train in endoscopy. We can't
Yes.
put it as a endoscopist like that.
We cannot suffix,
Yeah.
yes, endoscopist, we cannot put. Okay, then a few other questions. Pavan has answered quite a few. Always better to document pre-anesthesia checkup also in addition to anesthesia chart. Is there any changes for MLC cases? Like
Charges.
MLC charge,
Charges.
MLC charges?
Charges.
Can anyone answer this?
Sir
It
has
is there,
answered.
no, sir, it is there.
No, MLC
answered it.
charges, there are no MLC charges like that.
Yeah, I've answered it.
It
It is
is,
a hospital policy,
it
madam.
is hospital policy only.
Policy to collect fees, okay.
There is no
Because-
definitive rule regarding capping of fees. Only rule is to display the fees.
It's not related to capping. What I think so, Viresh has asked it that many hospitals collect MLC charges. If a case gets registered as
Extra charge.
MLC, they collect some 500 rupees or 1000 rupees depending upon the case, because in future, anytime you might be called for the court. So all that, considering all that, few establishments collect the MLC fees. So whether it is lawful to collect these fees is what was asked. It is left to the establishment whether to collect it or not.
adding to this
No.
consent
Can
about consent.
I add something?
Yes, sir.
Can I add something? No, it's not MLC charges actually. It's the wound certificate charges they charge. In the
Certificate
government
charges.
institutions also.
We can
That-
write
that
a
we
document
have-
charge, sir.
Sarvesh, that is in the government, it is there, but in the private,
No,
usually
in
they will
the
charge
private
us.
also. In private also, if you are giving a wound certificate, then it can be charged.
But
No,
when
not
the
at the
wound
time of
certificate-
giving wound certificate. At the time of
Possible,
admission
sir.
only,
Not
they
possible,
collect
sir, because wound
MLC
certificate
charge.
is collected by the police. Wound certificate is collected by the police. It is not collected by the patient party. So you can charge as a documentation charge to the patient. when he
Documentation
come-
charge.
Yeah, if he comes and asks for a copy of MLC, then you can tell that this much is documentation. Otherwise, general documentation charge you can put at the time of admission. You can't put as a MLC charge separately. That will attract some complicated legal terminology. So we better should not write as a MLC charges. Better you write as a documentation charges.
I doubt whether it will cause any legal implications because, see,
Yes, sir.
MLC case sheets has to be preserved for lifelong. That costs you some amount. And also the further implications of any MLC case has to be thought of. Because every time the court calls you, nobody is going to pay you unless you demand it. So you are legally bound to have your own charges as per the services you are providing.
Yes, definitely.
Yes.
Accepted,
So,
sir. Accepted.
So MLC cases should be preserved forever, and all other inpatient and outpatient to be preserved for 3 years up to the last date of follow-up.
Yeah.
Fine. Okay. Then Preeti's question: in spite of taking all care during consent taking, attenders eventually say they didn't understand and they just signed. So is it okay to make them write the consent in their own language?
It is better.
After
Safe
explaining.
practice, madam. But
This is a question.
yeah.
But explaining the medical terms and them understanding and them writing in their own language, it is quite a challenge.
Madam, what happens here is the consent, if it is there in Kannada also, and the patient knows Kannada or English, it is okay because it is written in simple language. If they don't know, we have one page left for them to write it in their own language. We make them write it in their own language.
Okay, like Bengali patient, what to do?
Yes, we ask them to write with interpreter also.
Yeah, that's a very safe practice. Majority of the cases are now they're happening on consent only. So consent should be taken care of. Like all this discussion, 80% of the take-home message is consent, 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 careful consent.
Only. What is not documented is not done.
Yeah. Shortly, there is an document getting released by this Institute of Medicine and Law on SOP on consents. So just I'm one of the reviewers for that. Maybe next month it will be released, and I'll share that document with the KSCASI social group also.
Just one or two questions. Let's finish it. What about the responsibility for a patient discharged from hospital and comes for a late complaint and comes with a stitch abscess, and the primary doctor is out of station?
The negligence from a patient side is also considered. That has to be documented. Because you have called on such date and he has not come on such date, and should be parallel arrangement should be made, because that is on humanitarian grounds and also on the hospital responsibility to make a parallel arrangement so that other doctor will see that patient and stitch abscess is done and abscess should be drained. And for that, there is a contributory negligence has happened from the patient side. So majority of the times, if you talk properly, carefully, they will not sue on us. Otherwise, they will go for a civil suit. Sometimes it is very bad means they will go for a criminal suit. So it's all how we talk and how we handle.
Fine. And Pavan has answered. So whatever Pavan has answered, I will skip. And Dr. Videsh's comment is, yes.
Madam, sorry. I think so. We are
done with it.
Zoom meeting is going to get closed. Just
we are done.
Wind up, madam, as early as possible.
So it's done. It's done. Because Pavan has answered quite a few questions on the
I would like to conclude, madam. I would like
please.
to conclude just in 1 minute. See, IPC, actually, civil negligence is when we do some smaller mistakes or something like some dose mistakes and something like writing mistakes and not documenting something and such things. Whereas criminal negligence is negligence when there is some really bad rash and negligent act has happened. For example, fracture has happened and you have put the patient on operating table, patient has fallen down and the patient has broken the leg, or otherwise you have removed right kidney instead of left kidney, or sometimes you have done operated on left eye or other than like right eye. Such criminal negligence, what it attracts is it attracts IPC. I will go through a little bit of IPC. Chapter number 4 in IPC, actually recently amended, but still the old IPC will apply. IPC 80, 81, 87, they work for consent, defense, and 88 for good faith, and 92 without consent and good faith. And chapter 11, they go for false evidences, what we give sometimes. IPC 191 false evidence, and 192 fabricating false evidences, 197 false certificate, issue of false certificates, and 204 destruction of document. For medical document you have destroyed, then 204 can be attracted, you have just burnt off MLC case sheets. Then chapter 14 goes for public health, where for example few cases has to be reported, like IPC 260 and 270, spread of infection. Chapter 16 offenses on human body, 304A, what we have discussed, Pawan sir told, 312 you causing miscarriage, 319 causing hurt, 322 grievous hurt. And also in some defamation case in 499. And that ends, I think, almost all the IPCs I have told for conclusion purpose. And I think we have covered majority of the things what I
We have answered all the questions also on this. Pavan has replied there. Dr. Narayan and Dr. Chandru.
Madam.
Please take over.
Siddhartha sir wanted to say something. Sorry, sir. Sir joined late. After Siddhartha sir's comment, I think so we'll wind up. Siddhartha sir.
Nothing more. I just wanted to add at that particular point where the video consent. See, the video consent, more of it is mainly because the patient is aware that a consent has been given. If you have taken a video consent, so there is always a chance that people go, they cannot take a stance that this was not informed. See, there is a moral blinding and they are aware that something has been done. They have a documentation. See, the writing, even if they have signed, they can always get away by telling I was not explained. So that is the advantage of video consent. More than legal thing, you have a moral binding on the patient. That's why. And another thing is, every time when a patient is in an ICU critical, you cannot go on writing everything what we have to convey. That is going to be cumbersome. So what we used to do, what we do is have a video on every day when you are consulting. What we are communicating, you record it. So that is a easier method also. You can take a pen drive, keep on adding to that, and then attach to the case paper and keep it. So that's one way of doing things. That's all. I just at that particular point, I wanted to say that. Otherwise, I think this is a good point. But you see, law is there. Law is always there to protect an innocent, at the same time to provide justice to people who are really grieved. But at the same time, the way law is being enforced also is important. And I hope there are a lot of fallacies there, which we also should remember. And that is where you have to represent your case well. Otherwise, even if you have not done a mistake, you may be caught. So that danger is always there. So we need to have proper knowledge and also proper representation. It is a painful process, but we need to go through because that is the only way right now. There is no alternative. So we are bound by this law. And I will tell you, I am in for this. After 35 years of my practice, I had my first case, so which I am going through. So we have to go through. It is not that just because you have finished 35 years now, I am 40. So 5 years back, the case has been filed. So it goes on. So it doesn't mean, it doesn't give an immunity. Seniority doesn't give you immunity, and your proper practices don't give you immunity. Yes. Thank you.
Yes, sir. Thank you, sir. It was an excellent discussion, Dr. Harsha, Kalaivani madam, Dr. Shailesh, Dr. Pavan. Really, it was mind-blowing discussion, which really happened. Everybody enjoyed and everybody participated. And we had a highest number of participants also. More than 75, 80 people had joined. It was really good. I request, I thank you all for doing the panelists and the moderators for doing this. I request our Chandrashekar to please present the word of thanks.
Yes, sir.
Thank you for the opportunity, sir.
Thank you for the opportunity.
Yeah, one
Thank
thing
you.
what I learned is
Dr. Prabhakar, sir, I missed you. Sorry, sir.
Okay.
see,
Chandru, please.
at the end of the day, take-home message is knowing along with the surgery, we need to know a little bit about the law also. And whenever you are in trouble, you
More
need
of
to.
law and less of surgery also is okay.
That is absolutely necessary. And behalf of KSCASI, I thank the moderator of today's panel discussion, Dr. Harsha GV, for an excellent moderation. And I think time was the constraint. Even if we have another 1.5 hours, we couldn't have completed this session. And I thank all the panelists, Dr. Kalaivani ma'am, Pavankumar Patil, Dr. Prabhakar sir, Dr. Shailesh, for their excellent participation, and all the members of KSCASI, our past president, national past president, Dr. Siddhartha sir, and the executive committee members of state and the ASI. I thank everyone for their active participation in this panel discussion. Thank you, everyone.
Sorry. Last point I wanted to highlight is never hesitate, whether it is junior or senior, so whoever it is, never hesitate to ask for help, whether it is on table or legally.
Yes, no egos. No egos. Yes.
No egos.
Whenever
no egos.
There will be a number
This
of
is the
people ready
purpose
to help
of
you.
having
So,
that legal cell what we have made, Pavan.
yes, sir.
This is the
Very
purpose
nice.
of the
Very
legal
nice.
cell.
Very nice.
Really a great thing.
Any member can personally message the legal cell so that we can take up and answer it in a very precise manner. They can message directly to any one of us, even to the secretary sir also they can message, so that he will direct it to us, or any of the panelists can be messaged to panelists. All of us will sit together, and otherwise we'll have a video chat and we can tell the conclusion.
Even during surgery also.
Thank you.
It's the best
If you
thing
need
an
help
association
any
can do.
day during surgery, always take your colleague's help or somebody's help. You will have safe results.
Yeah, we'll conclude this
We'll
session.
conclude, Chandra.
I think if you have more questions, please personally message to me or to Harsha. I'll reply back after getting the opinion from the panelists. If you have any more questions, definitely we are there to help. And we have a KSCASI legal cell which is activated this year. I think that will be continued for many more years. And anybody in trouble or any legal help, so definitely they contact the chairman or the secretary or the legal cell chairman. Definitely we are there to help the members of KSCASI. Thank you, everyone. Thank you very much.
Chandru, before everybody leaves, I want to say a few things. Okay. I request all of you are there, kindly celebrate the Surgeons Day celebration in a big way, all of you in the branches, and the blood donation move which has been initiated by National ASI. It's on June 15th. Please try to mobilize the people and donate blood as much as possible and have a celebration on that. And regarding our outbound tour, which is in Hospet, a lot of people have not registered. I request all of you to please join us. It's going to be a family outbound tour, which will be really enjoyable. Venkatachala is doing a lot of efforts on that. Please come forward and register.
We have around 35 to 40 rooms already booked. The 30 rooms are still pending. Please, see, you can imagine around 70-80 people already in. It will be a great.
All of you, please join. It will be really fun. We can all be together. And Harsha is going to be there. So we can Harsha, Pavan, and Kalaivani.
No legal discussions there, sir.
all illegal discussions can be done there.
Illegal discussions are
illegal.
Sir, Hampi is beautiful now. It is very cool and beautiful now.
Yes.
That's why the time was chosen, right?
Yeah, that's right.
Really
and Dr.
beautiful.
Naz also is putting a lot of effort there.
Yes.
Yeah, Naz Madam is arranged a special evening program on that day. So we should be there. All of us should be there.
I'm there.
And also we are arranging a vehicle from Bangalore via Tumakuru. So you can also use that way. Travel rather than driving.
Yeah. Thank you, sir. Thank you, everyone.
Thank you.
Thank you,
Venkatachala.
Thank you.
Thank you so much. Thank you, everyone.
Good night to all.